Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I'm joined as always by Miki Matrician, co-managing partner of our Boston office. How are you doing this week, Miki?
I'm doing well, Ken. How are you?
Doing pretty good. So we're going to dive in today, and this week we are discussing the impact of the federal government shutdown on immigration. So the federal government shut down at 12:01 a.m. on Wednesday, October 1st. And the shutdown impacts employment-based immigration because there are multiple government agencies that are involved with the immigration processes. The agencies include U.S. Citizenship and Immigration Services, U.S. Department of Labor, U.S. Department of State, Customs and Border Protection, and then Immigration and Customs Enforcement, including the Student and Exchange Visitor Program. So typically, in prior government shutdowns, the agencies that are funded by congressional appropriations stop working on matters associated with the immigration processes, and agencies that are fee-based remain open. Essential operations such as border security continue even though they are funded by appropriations. Well, we are now 2 weeks into the shutdown, and there does not seem to be an end to the shutdown in the immediate future, unfortunately. The last shutdown, which was from December 2018 to January 2019, lasted for 35 days, and the predictions right now are that this shutdown may last just as long. So, Nikki, let's break this down based on agencies, and let's start with Customs and Border Protection and ICE. So, how are these agencies impacted in a way that affects the immigration processes?
Yeah, so as you said, CBP ports of entry remain open. Inspection and enforcement staff are considered essential. So that means that they will work without being paid during the shutdown. There may be fewer officers at the ports of entry, which could delay the processing of some applications filed at the border, like TNs for Canadians and L1s for Canadian intra company transferees. And then the other agency you mentioned, Immigration and Customs Enforcement, or ICE. ICE oversees the SEVP, the Student and Exchange Visitor Program. And ICE enforcement actions do continue during a shutdown, as we've been seeing in enforcement actions in the news relating to Portland and Chicago. And with the SEVP, colleges and universities will continue to be able to access the portal for F1 and J1 holders. So, F1 students will continue to be able to transfer schools, get curricular practical training, as well as optional practical training and STEM OPT extensions as well. So, Kim, what are we seeing with the Department of State and consular processing of visa applications?
Yeah, so the State Department is responsible for visa and U.S. passport services. And because these services are at least partially fee funded, they will continue to be processed. However, it is important for everyone to know that the processing of visa applications as well as U.S. passport applications may be delayed given reduced staffing. So, this could be seen by longer delays in securing visa interviews, delays with issuing the visas and passports once the application has been approved, and longer administrative processing times, which require security checks from multiple agencies. So, HR and global mobility professionals may want to check in with employees that will be traveling and seeking visa appointments before they travel and or attend visa interviews in order to coordinate on plans in the event of delays. So the longer the shutdown continues, the more likely the consulates and or embassies with insufficient funds may limit their services to diplomatic visas and life or death emergencies. And Mickey, let's go back stateside and address the impact of the shutdown on the U.S. Department of Labor.
Yeah, well, the Department of Labor stopped processing cases on October 1st. They are not fee funded. So the applications that have been impacted include PERM, labor certification applications, prevailing wage requests, and labor condition applications. So the DOL's flag portal was shut down as of October 1st. And because LCA's PERM applications and prevailing wages are filed using the DOL's flag system, those applications can't even be prepared while the government is shut down. If HR and global mobility professionals have a printout of the flag wage survey information, they can, continue to conduct assessments and analysis for LCAs and prevailing wages to prepare for when the flag portal is back online. For HR and global mobility professionals, this means that employers that need certified LCAs for H-1B, H-1B1, and E-3 petitions won't be able to file those cases until the Department of Labor reopens. If there are employees with expiring statuses that need to file an extension, we are awaiting guidance from USCIS, which, in past government shutdowns, permitted extension filings without a certified LCA if the impact was due to the government being shut down. So, while we wait for that guidance, it's a good idea to have alternate strategies for business continuity. And then with PERM applications at a standstill, that may impact employees that need the certified PERM and approved I-140 petitions to be able to obtain H-1 extensions beyond the 6 years. So, alternative strategies might be needed for those cases. And with the inability to file prevailing wage requests and receive the prevailing wage determinations, this could impact employees who need that PERM application to be filed. HR and global mobility professionals will need to review each situation with counsel to determine the best path forward. And another big impact is the inability to file PERM applications during the shutdown, especially since recruitment expires after 180 days. And in prior shutdowns, we were able to file the PERM application via mail, but the Department of Labor closed the office that received those applications. And some of our colleagues in the immigration bar are attempting to mail in a paper filing to show at least, good faith attempt to file. We'll see how it plays out. Those applications may not be receipted in if the office is closed. So, what we did see with prior shutdowns is that the Department of Labor excused late PERM filings when the shutdown was the cause of the delay. And so, in those situations, Department of Labor treated the affected period as a tolling period, which essentially paused the filing deadline when its online systems were unavailable. So, if the Department of Labor goes by past practice, employers are hopefully able to submit PERM applications without penalty once operations start back up again, as long as the employers were ready to file during the shutdown period. Kim, what about USCIS?
USCIS is mostly funded through fees, so USCIS is processing and proceeding as normal, although the processing times could be delayed the longer the shutdown lasts. EB5 regional centers are not impacted during the shutdown, and the EB5 Immigrant Investor Program is authorized through September 30th of 2027, so that is not impacted either. There will likely be delays in certain cases, particularly if they depend on another agency for processing, such as biometric security check or obtaining a PERM certification from the Department of Labor. So there are some exceptions to the business as usual processes at USCIS. For instance, the Conrad 30 J1 waiver program may pause until appropriations resume. The Special Immigrant Religious Workers, which is for non-ministers, expired on September 30th, 2025, so that is not proceeding as normal. There also will be H-1B, H-1B1, and E-3 filings impacted because employers could not obtain the certified LCAs from the Department of Labor, as you mentioned, Miki. And then in prior shutdowns, USCIS excused the late filings where the shutdown was the direct cause of the delay. And some of that information is being posted on the USCIS website, but we'll continue to look for guidance. So in prior shutdowns, the E-Verify program went offline. And that is, in fact, what happened on October 1st of this year. And then on October 8th, employers noticed that there was movement with their E-Verify account. And on October 9th, USCIS announced that the E-Verify program had resumed operations, which no one was expecting because it's never had operations going during past shutdowns. So participating employers were informed by USCIS that they must create an E-Verify case by Tuesday, October 14th for each employee hired while E-Verify was not available because of the shutdown. And E-Verify stated that employers must use the hire date from the employee's Form I-9 when creating the E-Verify case. And if the E-Verify case cannot be created by the third business day after the employee began work for pay because E-Verify was unavailable, the employer is to select Other for the reason for the delay and then enter E-Verify not available in the text box. So the resumption of the E-Verify program was definitely a pleasant surprise as it can have such an impact on HR and global mobility professionals once the government reopens and all the cases for new hire employees are required to be created. So it was a shorter period of time where cases needed to be created. And we also saw some employers that were able to enroll and e-verify in order to move forward with STEM OPT extensions. So that's USCIS. Miki, can you provide us with one last update on our topic from last week?
Yes, the H-1B proclamation. So, unfortunately, USCIS has not provided any additional guidance yet on that front. Although we have in our offices seen approvals of change of employer petitions, change of status petitions, and extensions of status. The theory is that that is because the proclamation is an entry restriction. H-1B petitions that request or end up being adjudicated as consular notification, port of entry notification, or pre flight inspection notification are being held in abeyance. We are also still awaiting agency guidance on whether people who were approved as change of status petitions or change of employer petitions will become subject to the $100,000 fee if they depart the US. So we will keep monitoring the situation for agency guidance and we'll report back if there's any new development.
Great. Thanks, Miki. And with that, I guess that wraps up this week's Rapid Fire Wednesday. We'll continue, as always, with monitoring legislative, regulatory, and court developments, as well as agency guidance, and provide updates in future episodes as we hear of them. As always, for the latest updates to the immigration landscape, please follow WR Immigration on LinkedIn, as well as Miki and my personal profiles for breaking updates and insights. We also transcribe each and every Rapid Fire Wednesday episode and share it through our weekly newsletter, which you can subscribe to. The link to subscribe can be found in the video description. Thanks for joining us, and we'll see you next time. Always great to see you, Miki, and have a good rest of your week.
You too, Kim. Good to see you.